Today we have to talk about the likelihood of success of a Supreme Court case dealing with the Illinois quote-unquote assault weapon ban. This is a case I wanted to talk about a little earlier ago because there was a petition for a writ of cert to the U.S. Supreme Court. This is the case of Calkins versus Pritzker. Calkins versus Pritzker. It involves allegations that two of the Illinois Supreme Court justices have been bought and paid for by campaign donations, and therefore they cannot be fair and impartial brokers in this case. The question is whether or not this argument to the Supreme Court, which is based essentially in the Due Process Clause and the fairness of judicial proceedings, whether or not this stands a chance before the Supreme Court in the case of Calkins versus Pritzker. Let's talk about the details when we get back. Hey folks, I'm Mark Smith, host of the Four Box Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and nominee for two separate Gundy Awards for the year of our Lord 2024, one for Male Influencer of the Year, and for also Top Voice of the Second Amendment. I am honored to be nominated for these two Gundys for the year of our Lord 2024, and we'll see how it goes in January in Las Vegas when they announce the winners. All right, folks, so we have to talk about this case of Calkins versus Pritzker, Pritzker being the governor of Illinois. Right now, the Calkins versus Pritzker case is up before the Supreme Court on a petition for cert. Specifically, the lawyers in support of the Second Amendment are arguing that the Illinois Supreme Court, this is a Supreme Court case out of Illinois, state claims, state issues, all that in the state system. The question is whether or not the Illinois Supreme Court can be fair and impartial in resolving questions about whether or not the quote-unquote assault weapon ban from Illinois involving semi-automatic rifles and magazines that hold more than 10 rounds, whether or not this state-based law violates, among other things, the state constitution, and whether or not the state Supreme Court in Illinois can hear this, specifically whether or not two recently elected justices on the Supreme Court, Justice Elizabeth Roqueford and Justice Mary O'Brien, whether or not these two justices can be fair and impartial in this case, where they received over $2 million in campaign donations in one way or another from those that were supportive of the assault weapon ban, who had publicly represented commitments that they supported the assault weapon ban that they're now overseeing, and that specifically there was a $2.6 million in campaign contributions allegedly to Justice Elizabeth Roqueford and Justice Mary O'Brien by or on behalf of essentially the defendants in this case. Now, here is the bottom line. I think this request, although I'm very sympathetic to it, and I would love for the plaintiffs in this case, Dan Calkins and the others, to prevail, I'm afraid there's not a lot of chance of this prevailing in the U.S. Supreme Court. And here's why. The argument is essentially that the two justices on the Illinois Supreme Court that received these campaign contributions could not preside over this case, and this violates the 14th Amendment's Due Process Clause, because it means, according to the argument, it's not a crazy argument, that the plaintiffs who are seeking to vindicate Second Amendment rights and to strike down the so-called assault weapon ban, that this violates the due process of those plaintiffs because they're not getting a fair and impartial hearing in front of a fair and impartial group of Supreme Court justices there in Illinois. Well, that argument is not offensive, and nor is it a crazy argument, but the reality is this. The relevant case law is a case from 2009, a United States Supreme Court case from 2009, called Caperton versus A.T. Massey Cole. Now, I'm not going to get into the details of this case beyond saying that it was a 5-4 decision by the U.S. Supreme Court, with Justice Kennedy doing his Justice Kennedy thing. He's no longer on the court, of course. But Justice Anthony Kennedy was the deciding vote, who went along with the liberals to say that, sure, in this particular context, where there were donations made to a Supreme Court justice in the West Virginia Supreme Court by individuals that had a case coming up before the West Virginia Supreme Court, dealing with a jury verdict, I believe, of like $50 million against a coal company. And therefore, the U.S. Supreme Court, in a 5-4 decision, with Justice Kennedy being the deciding vote, said that this indeed violated the Due Process Clause, and that the judge in that case in West Virginia, that Supreme Court justice in the West Virginia Supreme Court, should have recused himself, and his failure to do so denied the parties who lost in that West Virginia Supreme Court case, deprived them of due process. Now, that 5-4 victory, again, was the 4 liberals on the court plus Justice Kennedy. The people that were in the dissent in that case of Caperton versus Massey are going to sound very familiar to you who follow this court. The dissent was written by Chief Justice John Roberts. Justice Scalia joined with the dissent. Justice Clarence Thomas and Justice Sam Alito all also joined with the dissent, claiming that this campaign contribution situation in West Virginia did not violate the 14th Amendment Due Process Clause. Among other things, they pointed out, and this is what the opening line of this dissent, and the reason why I bring this up, of course, is if you look at the composition of the Supreme Court today, all the dissenting judges in the Caperton case that said that the campaign contribution in the Caperton case did not give rise to a 14th Amendment due process problem are still on the court. So it seems to me that there's no way you're going to get to 5 votes to say that the Illinois Supreme Court justices of Elizabeth Roquefort and Mary O'Brien are somehow going to have to recuse themselves under the federal 14th Amendment, because, again, I don't think there's 5 votes to say they should. And that doesn't mean that Justice Roquefort and Justice O'Brien should not do so, because it's not just the being fair as a judge. You also need to appear to be fair. You have to appear impartial so that people trust the system. And you can certainly argue that given the situation with Justice Roquefort and Justice O'Brien receiving these campaign contributions from defendants in this case, that may not look that fair, but again, doesn't give rise to a federal due process violation. Certainly, I would say there's 5 or more votes on the U.S. Supreme Court that says it does not. I will put a link to this Caperton versus Massey case, and for those of you interested, take a look at the dissent by Justice John Roberts. And by the way, there's an additional dissent by Justice Scalia, who disagreed with the decision by Justice Kennedy and the 4 liberals in the Caperton case, which is the critical precedent, of course, that the plaintiffs in the Calkins case, on behalf of the Second Amendment, are trying to hang their hat on, but I don't see how they get to 5 votes in the modern era. Specifically, what Chief Justice John Roberts writes in the dissent, saying that the donation in the West Virginia case did not give rise to a basis to force under the 14th Amendment a justice on the West Virginia Supreme Court to recuse. This is what Justice Roberts wrote in his dissent. I, of course, share the majority's sincere concerns about the need to maintain a fair, independent, and impartial judiciary, and one that appears to be as such. But I fear that the court's decision here will undermine rather than promote their values. The court goes on, specifically Justice John Roberts in his dissent in the Caperton case, lays out, and this is quite impressive, 40 questions that have gone, that now have to be addressed by the lower courts thanks to the Caperton case. What Justice Roberts and, of course, the other 3 justices that agreed with him on this dissent point out that there are other fundamental questions as well. With little help from the majority, courts will now have to determine, and then he lists the 40 questions, which are quite extensive. And to make things even worse as to why I think they can't get to 5 votes in this Calkins case, Justice Scalia himself actually did an add-on dissent. And what Justice Scalia said was, the principal purpose of this court's exercise of its cert jurisdiction is to clarify the law. As the Chief Justice's dissent makes painfully clear in the Caperton case, the principal consequence of today's decision is to create vast uncertainty with respect to a point of law that can be raised in all litigated cases in at least those 39 states that elect their judges. This course was urged upon us on grounds that it would preserve the public's confidence in the judicial system, but he goes on to point out that essentially this is not going to be the case. And as he sums up in Justice Scalia-like fashion, who is always quite entertaining writer, he writes, a Talmudic maxim instructs with respect to the scripture, turn it over and turn it over for all is therein. Now, Justice Scalia goes on to say that divinely inspired text may contain the answers to all earthly questions, but the Due Process Clause most assuredly does not. So again, while I applaud the plaintiffs in the Second Amendment case of Calkins versus Pritzker, and I wish them well and I hope they prevail, the reality is I don't think they can possibly prevail with the Supreme Court given who is in the majority, including Chief Justice John Roberts and other conservatives that remain on the court, and of course that powerful dissent by the late Justice Antonin Scalia. So I don't see how the Calkins case can get to 5 votes to unfortunately wipe out the Illinois Supreme Court decision upholding, if you will, the Illinois state quote-unquote assault weapon ban. So I don't think this is going to be fruitful effort on behalf of our right to keep and bear arms in Illinois. But the good news is I think we're going to get to where we need to be through other legal venues and other legal paths. Nevertheless, I just wanted to bring you up to speed as to how I see the Calkins case. Maybe I will be pleasantly surprised, but again, it's not my job to simply talk about rainbows and unicorns with you. I have to tell you what I think is going to happen in these various cases. Even when I'm not satisfied or happy about the outcome, I still try to be a straight shooter with you to the extent I can be. So, all right. Well, I hope you've enjoyed today's video here at the 4 Boxes Diner. Make sure you share this video and like it and subscribe. And don't forget to follow me on X at 4 Boxes Diner. And we will see you again soon here at the 4 Boxes Diner.
Orders up. Table 2A.